Be ready and start. It has been submitted by the learned senior counsel for the appellant that the time period for presentation of challan would be that of 60 days, as his case falls within the ambit of section 167 within bracket 2 of the criminal procedure code stop. It has also been argued by the learned senior counsel for the appellant that the investigation agency is required to file complete challan within a period of 90 days stop. Ordinarily, in a case of murder, the punishment prescribed is either death or imprisonment of life stop. In such a situation, admittedly, the investigating agency has a time period of 90 days to conclude the investigation, following which the accused can claim has right to seek statutory default bail as per provisions of section 167 criminal procedure code stop. However, in case a child in conflict with law in facing trial for the offense of murder, he can neither be sentenced to death nor for imprisonment for life without the possibility of release in view of provisions of section 21 of the Juvenile Justice Act. Section 21 of the Juvenile Justice Act is reproduced as under stop. No child in conflict with law shall be sentenced to death or for life imprisonment without the possibility of release for any such offense, either under the provisions of this act or under the provisions of the Indian Penal Code or any other law for the time becoming in force stop. As per said provisions of section 21 of Juvenile Justice Act, a child in conflict with law can neither be sentenced to death nor can be subjected to life imprisonment without the possibility of release. The case of child who is in conflict with the law and facing investigation or trial for the offense of murder is on different footing than that of an adult accused facing an investigation or trial for the same offense stop, since no minimum punishment is prescribed to be imposed upon a child who is in conflict with the law. The case of said child in conflict with law would fall within the domain of section 167 within bracket 2 criminal procedure code. Accordingly, the period of 60 days is there to conclude the investigation and not 60 days. The relevant part of section 167 criminal procedure code is reproduced as under stop procedure when investigation cannot be completed in 24 hours stop. The magistrate to whom an accused person is forwarded under this section may, whether he has or has not jurisdiction to try the case for time to time, authorize the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15 days in the whole, and if he has no jurisdiction to try the case or commit it for trial and considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction stop.